All power to the people. I want to personally salute the churches of Berkeley and the council at Berkeley that had the courageous foresight and the ability and the courage to give support to deserters of this unholy and illegal war that's being carried on by this administration, which is a carryover from the previous rotten administration. I want to talk to you, if I may, since most of you are planning to be lawyers. I don't know why. Anyway, you're embarking upon a pre-legal education. There's nothing wrong with being a lawyer. But the things that I want you to remember and the things that I want you to think about are in the area of what we call justice. Do we have justice in our present administration of law? Are we interested in justice? We cannot have justice in our courtrooms unless we have social justice. We cannot have justice in our courtrooms unless we have economic justice. As long as we have 16 million people going to bed hungry each and every night, you're not going to have any form of justice. As long as we have the ghettos of America, both red, yellow, brown, and black, you're not going to have any form of justice. The cry of law and order is not going to solve the problems of what we call justice in our courtrooms. Packing our courtrooms with judges who are either political hacks, drunkards, incompetent, and senile is not going to bring us social justice, much less any form of justice. I am not blanketing all of our judges in that category. I'm only blanketing 75% of them. The other 25% are men and women, very few women, of goodwill, who consider themselves to be liberal, who read with pride the opinions of Justice Brandeis, and in the later years of the life of Holmes, they read his opinions and Cardozo's, and they mouth off liberal platitudes. But when it really comes down to the nub of actually having some intestinal fortitude, or to use the common denominator of guts, they fall short of that. 25% of our judges fit into that category. The other 75% are old hardline, racist. Now, to be sure, they don't consider themselves to be racist. I have yet to meet my first racist who would admit being a racist. Even if you were to ask Adolf Hitler, if you could go back 30 years, and say to Adolf Hitler, "You are a racist," he would say, "Absolutely not. I'm a great humanitarian. I did the Jews a favor by exterminating them." And when he referred to black Americans as apes and monkeys, he would only say that I'm being charitable. Nothing has changed just because World War II ended with the so-called demise of Adolf Hitler. We have our Adolf Hitlers in various degrees throughout our nation. The Kerner Report in 1968, on July the 1st, came out again and pointed out that black Americans had lost confidence in the system. They'd lost confidence in the system to such a point that they did not want to participate in any of the functions that the man has created for them. The Kerner report pointed out that black Americans would not vote in the same proportion the white Americans would. They did not feel that they were part of the system. They felt that the entire establishment was established along racist lines. The Kerner report pointed out that some 2/3 of white Americans are overt, that's objective racist. The other third were not overt racists, but were subjective racists. Put it bluntly, every single white American, including myself, have elements of racism within ourselves. If it's true that the Kerner report said that, we have a further example in the state of California, where in 1964, the Rumford Fair Housing Bill was the law of the state of California. A group of racist real estate operators and their friends introduced a constitutional measure called Proposition number 14. Proposition 14 declared that it would be unlawful and illegal to have a fair housing law. Almost 67% of the white Americans in the state of California voted in support of that constitutional amendment. 67%. Pray tell, if as the Kerner report and subsequent reports and reports prior to the Kerner report and many of the other studies that have been made point out that some 66 2/3 or 67% of white Americans are overt racists, then isn't it also true that the same percentage of lawyers, white lawyers who are practicing law in the courts of our land, are also white racists? Isn't it also true that the judges are themselves part of that same percentage? Isn't it also true that the jurors of the jury panel are at least 67% overt racists? Now, what stretch of the imagination and what yardstick, if you were one of the attorneys defending a black American, and particularly a black revolutionary, for that matter, or a brown revolutionary, or a red revolutionary, what standards would you use to determine and eliminate the 67% or the 66 2/3% of the judges that you come before, or the jurors that you come before, and the court attaches? How would you get rid of them? What kind of a yardstick would you use? What kind of a magic wand would you put over their head and say, this person is okay and that person is not okay? This is what we were facing when Huey Newton went to trial in 1968, charged with the killing of a police officer, charged with the attempted assault with a deadly weapon on another police officer, and kidnapping. The entire county was electrified. Huey was found guilty before the trial ever started. He was found guilty the day that the incident happened, as far as the media was concerned and the press. We went to trial. We pointed out that you couldn't get a fair trial, that Huey Newton couldn't possibly get a fair trial. We pointed out the things that I've been telling you about. We pointed out that in the county of Alameda, where it's divided into 7 judicial districts, in 5 of those judicial districts, there's less than 0.5% of black Americans living there. The other two judicial districts, that's the one of Oakland, Piedmont, 38% were black Americans. Berkeley, with a heavy concentration of not only black Americans, but white Americans and brown Americans and yellow Americans and red Americans who are somewhat concerned and who relate to the problems that we're talking about. We pointed out that and used the 1964 Proposition 14 as a standard, that the total county of Alameda voted in support of Proposition 14 in the same percentage ratio as the rest of the state did. We pointed out that in the city of Oakland, for instance, where you have 38% black Americans, 54% voted against Proposition 14. We pointed out that in the city of Berkeley, which is a township, that almost 72% voted against Proposition 14. But we pointed out that the other 5 counties overwhelmingly supported Proposition 14, and that is to outlaw fair housing. For instance, in San Leandro, for instance, the percentage of the vote in support of the law to outlaw Proposition 14 was almost 87%. And yet, when you start picking a jury in Alameda County, you pick a jury from the entire area of the entire county, it's impossible to be able to detect the overt racist and the extent of the subjective racist in this present trial, where Huey Newton is now on trial for the 3rd time. We made a motion that the jury be composed of men and women who live in Alameda County, but particularly to come from the Oakland, Piedmont area, because that's where the so-called crime took place, and that's where Huey Newton resides. Municipal court juries come from there. The judge denied that. To give you a little sideline of one of the jurors, born in 1893, a real peer group, you know. I said to her, "Do you have an opinion about the Black Panther Party?" "Well, no." Well, I said, "Have you ever heard about them?" "Yeah." "Well, what have you heard about them?" "Well, about their breakfast program, which I think is a phony." I said, "What do you mean it's a phony?" He says, "There's not that many hungry children." Now, can you imagine going to trial before a woman or a man who doesn't think that there's that many hungry children? Thousands of children have been fed by the Black Panther Party, and there's thousands and thousands and thousands more that should be fed. And this woman sitting there with her 1893 mentality, there's not that many children. Now, that same type of mentality occurs with the judges and the lawyers. The lawyer that comes to court with his Eldorado Cadillac or his Lincoln or with servants at home is not the least bit concerned about the problems we're talking about. And it's those type of lawyers that get appointed to the courts. I've had lawyer after lawyer say to me over the periods of years that I've practiced, say, "Garry, I don't know anything about criminal law. I don't want anything to do with criminal law." And 10 years later or 15 years later, that same person becomes a judge. He's appointed a judge by the political power to be. And you know where the first assignment that he's given? In the criminal courts. And he sits in the criminal courts telling me what the law is, a man who never knew anything about it where he wouldn't soil his hands. We have a new problem today. The new problem today is that we have men and women in prisons who have lost all of their confidence in the system. They were sent to prison because they couldn't make a living, so they stole. Whatever they did, they went to prison. Our prisons are warehouses of human beings without any direction to make and change conditions so that when the man or the woman leaves prison, he will be able to return to something that was better than that he left. Not only he spends these dead periods in prison, the periods that he spends in prison are humiliating, degrading. It's not constructive. They have no rights in prison. One warden said to me one day, he said, "This is not a summer resort." I said, "I appreciate the fact that it's not a summer resort, but what are you doing so that that man or person that you have under your custody will be able to return to what you consider the private social life and be as you have put out, a contributing asset to society?" Well, he said, "That's not my problem, that's the legislature's problem." Well, the men and women of prison are no longer interested in that kind of a salvo. They have decided for self-help. One inmate told me the other day that I'm living amongst the living dead. And he said to me that as far as he was concerned, if he could not live with dignity, he was not going to live without dignity. And he told me that this is shared by a great preponderance of the men and women in prisons today. Sunday before last, I had the opportunity to participate in the People's Tribunal in Brooklyn, New York, where we put on witnesses to testify to conditions and what happened at Attica. And a murder indictment was lodged against Nixon, Rockefeller, Oswald, Mancuso, and the head of the state troopers. We presented evidence for 4 solid hours. This was not hyperbole evidence. This was not hot air evidence. This was evidence of men and women who participated at Attica during the negotiations. We brought in former convicts and their wives to testify to conditions that they witnessed, not only at Attica but in Auburn. Over 4,000 people were there. That story is being filmed. I had the opportunity to be the so-called prosecuting attorney, and it was the first time I've ever played that role. It's kind of a peculiar feeling, especially when you win. I'm mentioning these things because as you become future lawyers, and if you're thinking of this area of becoming an attorney, you've got some decisions to make. Right now, there's 6 inmates who are charged with 6 varieties of murder at San Quentin. They have demanded that they have the right to select their own attorneys. Since they're indigent, since they have no money, and the courts in Marin County have stated that they're not going to have the opportunity to select their own attorney, that they're going to pick the attorney for the inmates. Now think about that for a minute. If you have money and can afford it, you can have whatever lawyer you desire. But if you are poor and an indigent, You have to take the lawyer that's being designated to you. Now, we're not talking about the public defending system now. We're talking about court-appointed lawyers, because a court-appointed, the public defender obviously cannot, in any stretch of the imagination, represent all six, because there's obvious different interests. There may be conflicts amongst the six as far as the evidence is concerned. But the court, instead of picking the lawyer that the inmate has chosen, that he has confidence in, has picked lawyers that the clients have never heard of. Now, what do you think is going to happen there? Can you imagine those 6 men who are facing the gas chambers of the state of California putting up with that? Now, when they object to the conduct of the court in these arbitrary decisions, then of course the law and order cry, the law and order people are going to say, these unruly defendants misbehaving, just as they said about Bobby Seale, where in Chicago, when his attorney was denied a 6 weeks continuance so he could have a gallbladder operation, forced him to go to trial, and would not even permit Bobby Seale to defend himself. And he didn't even hold a hearing in order to determine whether he had the ability to be able to defend himself. Pre-trial detention. Pre-trial detention. Sure, occasionally we get victories. Occasionally we win a case. And then when we win a case, they'll say, see, the system is working. Let's take the case of the La Siete de la Raza, which is 7 Chicanos were charged with the murder of a police officer in San Francisco. Before that case came to trial, those young men had to spend approximately 2 years in prison awaiting trial. While they were awaiting trial, now these were students. They were not permitted to have any of their books. They were not able to do anything constructive while they were in prison awaiting trial. Now, they have not been found guilty. And they were subjected to the most severe and degrading form of harassment. 2 of the young brothers had contracted a jaundice condition. They weren't even able to get medical attention. After 5 months of trial, the jury acquitted them of murder. You might say the system was working. You know, this theory of fair trial, quote, fair trial, end of quote, is a term that's been created by lawyers and judges. It's a false term. It doesn't mean what it says. Because if you're going to have a fair trial, then there's got to be a balancing of powers on each side. Do you have a balance of each side, the so-called adversary system that you're going to hear an awful lot about as your time goes on in the so-called pre-trial or the pre-legal training that you're going to have? The adversary system, as far as lawyers are concerned, as far as judges are concerned, is that there's a judge sitting in the middle of the courtroom with a black robe and making noises like he's neutral, and a lawyer sitting representing the so-called people, and on the other side there's the lawyer representing the defendant. Now, it's true that it's a tripartite situation with a defense counsel and a prosecution and a judge. But it isn't that at all. Why isn't it that? Because before you can have an adversary system that's equal and that there's balance, you've got to have power on both sides. The defense has no rights except to be able to dig out what they can ferret out. The defense does not have the right or the power to be able to have the weight of the state behind it. I noticed in the juries that I've been picking, and even in the last one, the prosecution has a rap sheet of black prospective jurors. Now pray tell, how many black men and women who've lived in the ghetto can get by without having some kind of a harassment at the hands of the police? But the district attorney has that rap sheet on these black prospective jurors. And it embarrasses the person that's on that jury. No wonder they don't want to sit on there. And if you understand the Kerner report and all of the other reports, you'll understand that black Americans in the ghettos of America get harassed and hassled constantly. That's why the Black Panther Party was created. So that you don't have the benefit of even knowing what the other side knows. You don't have the power to be able to investigate and find out some things about the witnesses that the state will draw in there. The first time that I put a witness on there, they have the benefit of contacting the Federal Bureau of Investigation and the Central Intelligence Section to be able to get the information. They have the power of the state behind them, unlimited power. In the case of Angela Davis in Marin County, the state has already spent $1 million. They've gone to the legislature to get some more money in order to continue the prosecution. Pray tell, where does the defense be able to match that kind of effort? Unless the lawyers themselves and friends of the defendant are willing to make these financial contributions, men and women get railroaded to prison every single day. Another thing that I want to call your attention to along the same lines. The state has at its control the ability to be able to give a particular witness who refuses to testify upon the grounds that it may tend to incriminate him. The state can give that witness immunity so that the witness can go and sing its heart out. The defense cannot do that. And in the case of Huey Newton, it's a classic example. In the 1968 trial, a witness by the name of Del Ross took the witness stand. He refused to testify upon the ground it would tend to incriminate him. He was a prosecution witness. The judge and the district attorney couldn't give him immunity fast enough. Later on in the trial, I put on a witness. I subpoenaed him. He was a passenger in the car that Huey Newton was riding in. I asked him the question, did you kill Officer Fry? He took the Fifth Amendment and refused to testify. I said to the judge, why don't you give him immunity so he can talk? Don't you think it's fair? Don't you think if you're going to have an adversary system that there should be adversary rights? That there should be a balancing of strengths on both sides? If you're going to have an adversary system, you should have it. You shouldn't have a situation where you have the power of the state with all of its billions behind it, all of its power behind it, all of its police state behind it, against the lonely defendant sitting in there with the lawyer with his pompousness, playing the game that this is a fair trial. It is not a fair trial. Hasn't even got the semblance of a fair trial, and I'm not the least bit interested in the fact that men get off. Look at the expense that you go through to get off. This is Huey Newton's third trial. I don't know how many more there will be. I tried one Panther case 5 times. Fair trial? 60 million Americans today, black, brown, yellow, red, and poor whites, do not get any semblance of justice in our courtrooms. We have what we call the plea bargaining method of justice, where you're charged with a group of charges against you, and you try to make a little bargain by pleading guilty to one, and they'll dismiss the others. When in fact you may be absolutely innocent of all of it, but you can't afford to take a chance and stand trial. Now, plea bargaining has been approved by the Supreme Court of our state and also the United States Supreme Court. I'm just pointing out some of the problems that you're going to run into. And these are the problems, and I've just briefly sketched on them, that causes the unrest, causes the turmoil, causes what we call dissent. It's no longer dissent. Our brothers and sisters of our ghetto areas have nothing to lose. They're no longer going to continue on bended knees with shoe black on their lips. That is certain. Unless the courts recognize, since they are the bastions of the establishment, they're trying to preserve the status quo. Unless they recognize this, there's going to have to be a lot more bailiffs and the National Guards in the courtroom in order to what they consider security in the courtrooms. You can't walk into a courtroom anymore and defend a person who's even charged with the mildest form of dissent without the courtroom being an armed camp, a barricade. If you don't believe it, come to the Huey Newton trial, the administration building. They picked the smallest courtrooms so that the people will not be able to attend. The public trial has become a mockery. In the Soledad trial in San Francisco, the persons who go there to participate and sit in the trial are degraded by the type of search that they're subjected to. The women have to take their panties off, have to be examined. And the judge, this courageous judge, this judge who should be leading the March of the Fleas, said the other day that he took judicial notice that it's been known that women carry weapons between their crouches. You know, there's a statement and a saying, and let's not forget it. Don't you ever forget it. When law is tyranny, revolution is order. Thank you.
For the admission officers that are here from law schools, lunch is being served now at the faculty club. Charles Garry will now answer questions from anyone. One other thing, this afternoon from 2:30 till 6, representatives from law schools will be here in Pauley Ballroom to answer any questions, any problems that anyone may have. If anyone's interested in law or any field related to it, you should come this afternoon. Thank you.
I didn't hear your question. No, I refuse to get involved in that kind of discussion. It's not my area. It's not my business. The Panthers are quite capable of speaking for themselves. Question is, what's my opinion of the nominees of the Supreme Court of the United States? Need you ask that question? The attorneys that were appointed for the defendants in the San Quentin case in Marin County were allegedly members of the Bar Association who live in Marin County. The basis upon which the courts have ruled that Angela Davis is not entitled to bail is that she is charged with a capital offense, and the probabilities of her getting the death penalty are very probable, and for that reason she's not entitled to bail. I don't agree with that percentage. who declares that percentage, whether they're 50 or 90%. The question was, how do I get around the fact that between 80 and 90%, is that the figure? How do you get around the fact that 80 to 85% or 95% of the persons are guilty who go to court? Is that your question? Well, those figures have been arrived at by the fact that the person has pled guilty. And he's pled guilty because of a compromise, so that those percentages don't mean anything. That's what plea bargaining is. You're charged with a crime, and you go ahead and plead guilty in order for you to be able to get a less severe sentence or probation or something else. That's how those percentages have been raised. That's how the percentage operates, and it has no reflection on the facts whether the person is guilty or innocent. Many a person has pled guilty in order to expedite and get rid of a cumbersome problem. As a matter of fact, in some of the early days of your sit-ins in the University of California, many people pled guilty as a blanket situation when many of the persons who pled guilty were not even on the campus or anywhere near the situation at the time. But it was much easier paying a $28 fine or getting a 10-day suspended sentence or putting in 2 days in jail than it would be going in a protracted trial that would take 6 months and go through all kinds of hassles of losing time from work or time from school. I'm going to let you people decide what's to be done. He said the defense cannot make that demand, and it's only the prerogative of the prosecution. And that's the way the legislature created it. That's the state law. False illusion, we're living in fairyland if we think that one person can change conditions. These jails are made for the benefit of the establishment. These jails are made for the benefit of the courts, and no matter how well-meaning any particular one person may be, he's not going to be able to make the changes that are necessary. However, that doesn't mean that you do not elect a person of that kind who can be part of the struggle and part of the aims of exposing the corruptness of our entire social structure. Did you all hear the question? He's quoting Chief Justice Berger, that those young people who think they're going into law because they can contribute to a viable change in our social structure are going to be sadly mistaken. He's absolutely right. Lawyers are not going to change anything. I haven't been able to change anything. All I'm able to do is to snatch a person here and there out of the clutches of the establishment so that they can go out and make the changes that have to be made out in the streets. All you have to do is say you don't have an opinion about the case. That's what the other side does. You know, there was a time whenever I'd see a long beard and long hair, I was tickled to death to have them on my jury. But unfortunately, some of the straight people are now starting to look that way. And so when I see a long hair and a beard, I have to ask a lot of questions. So that in answer to your question, I think the establishment is moving into the long hair and the beards. I just want you to know that. Yes, I think that there's an answer to armed struggle if the power of the people, which is supreme, is exercised. But that's a little different in the areas that I want to concentrate on. That gets into another area of political action. I let my clients make those decisions. The alternative remedies I would suggest is in the field of social and economic change. You see, the policeman, we blame the policeman constantly for whatever is happening. The policeman is only an agent of the state, and the judge is the mastermind of the agent of the state, and they're all committed to present and prevent any changes in the status quo. And unless we start getting people's courts, unless we get people's judges, we're still going to have judges who belong to the Elks Club, which is an all-white organization. We're still going to have judges who think that anybody that has long hair is a danger to the community. Anybody that's been on a picket line is a danger to the community. The changes have to be made not in these technical rules of evidence, suppression of evidence. The problem is much deeper than that. I said that you cannot have justice in our courtrooms unless you have social justice, economic justice. You know, in Les Miserables, Jean Valjean went to prison because he stole a loaf of bread. You know, that condition hasn't changed in all these many years. Victor Hugo's portrayal of Jean Valjean exists today. We live with it, and we participate in it. I think the right of a person to be able to eat and have shelter should be an inalienable right, just as your right to be able to breathe the air without any contamination. I believe in the adversary system if it's truly an adversary system, but I don't believe in this lopsided business where the adversary system has been limited as to whether a person has a lawyer in a courtroom or not. That's not an adversary system. I don't believe in that. Yes, it does. As a matter of fact, our law schools are part of the same administration of justice in the areas that I'm criticizing. You're taking courses in law school that are irrelevant to your needs. The law schools have to be revamped, just as our courts and our social structure has to be revamped. But in the meantime, those of you who are interested in the rights of human beings have got to be good mechanics and good law students in spite of the fact that you're taking a lot of junk that you don't need and you shouldn't have to need. With that, I think we'll end. Thank you. Where do I sign it? I need a lawyer for this.
How about a law student?
Law student. Yes, I'm hungry. So Karen's coming with it.